Hello, I'm David Roger, General Counsel for the Las Vegas Police Protective Association. In this video, I would like to talk to you about consensual searches. And the case that deals with consensual searches is Schneckloff versus Bustamante. You can find it at 412 U.S. 218. It's a 1973 case out of the United States Supreme Court. And the U.S. Supreme Court in that case gives us a little bit of direction, but not much. The courts will look at the totality of the circumstances to determine whether a suspect has voluntarily given you consent to search. And as you might imagine, there are very few cases that provide you with a bright line rule. Instead, it is fact specific, and there are a number of factors that we draw out of all of these cases. And so, always remember that your body camera is on, and so all of your contact with the suspect or the person giving consent will be reviewed by the court. So here are a couple of factors. And not one of these factors is determinative. Obviously, it's the totality of the circumstances. One, tell the person that they don't have to consent. Obviously, if you've told them that they don't have to consent and they nevertheless do consent and give you written consent, although that's not required either, the more likely a court is going to look favorably on whether the consent was voluntary. These next couple factors are what I consider or consider the use of force or dominance. One, plainclothes officers, and so this is, I guess we should call it show of force. And so if it is a plainclothes officer, then there's not that uniform, that show of authority. Fewer officers, if you have a number of officers around the person who's giving consent, the more likely a court is going to say that the person was overcome by this show of force. Use of weapons, obviously you're not going to stick a gun to someone's head to get them to consent. Trickery. Now this is important because these cases where officers have used trickery have been invalidated by the courts. Don't tell them that you have a search warrant when you don't. If you don't have a search warrant, obviously you're asking for consent. Don't tell them that you have one. Don't tell the person that you can get a search warrant when you know you don't have probable cause to get a judge to sign a search warrant. So those are what we call show of force factors. Next, brief contact with the individual. If you're browbeating them over a period of time, the less likely a court is going to find that the consent was freely and voluntarily given. The tone of your voice is important, or could be a factor. Next, Miranda. If the person is in custody, read the Miranda and have them acknowledge their Miranda rights. And there are other factors that you don't have any control over. The age of the individual, and so the younger the person giving consent, the less likely it is that it will be voluntary. The person's fluency in English. Obviously, if you're dealing with someone who doesn't speak English, make sure that you have an interpreter and take special care in those circumstances. The mental or physical capacity of the individual, probably more importantly, the mental capacity of the individual plays a factor. And a factor that you probably wouldn't think of is the person's experience with the police. If the person has been arrested numerous times, then that person is less likely to be overcome by your influence. And so those are some of the factors that the courts look at when reviewing the totality of the circumstances to determine whether consent was voluntary. Thank you. As always, feel free to contact me at DRoger@lvppa.com and subscribe to our YouTube channel, and then obviously check out the mobile-friendly website, DRoger.us. Thank you.
111, 110.